Feel like I should have some theme music when class is about to begin, but I am clearly slacking in that department, so I apologize. It's just my horrible voice instead. What you're about to listen to for the next hour and 15 minutes. Yay! A couple of ground rules. Well, first and foremost, in case you don't know why you're on, we are doing my What's That Form, WTF. I know, I'm clever. The purchase contract. Because the purchase contract is so lengthy, I've divided this up into three sections. So hopefully you saw that when you registered, but we're going to do sections 1 through 3 this morning, just so that you can get about your day. Otherwise, we're going to be on Zoom for like 4.5 hours, and nobody wants to do that. Some general ground rules. Please keep yourself on mute unless you are asking a question. I have been known to publicly humiliate people on these classes because they have unmuted themselves and we can hear their entire conversation. That has nothing to do with the class. We do not care what your sister's, baby mama's, brother's friend is doing this morning. Please and thank you. Please ask questions out loud just so I don't have to monitor the chat box. It's just a distraction. And sometimes there's follow-up clarifications. So it's just easiest, put yourself off of mute, ask the question for the good of the group. And I will send this slide deck and a link to the recording of this class to everybody who registered. So if you think you potentially missed something, or if you wanted to try to take photos of the different slides, don't worry about it. All of that will be coming out to you later today. All right, so let's get started with my favorite thing, which are some polls. Let's test a little bit of your knowledge or lack thereof to get going. So poll 1, I have a couple of different questions on this one. True, false, earnest money must be at least 1% of the purchase price. Number 2, when does close of escrow occur? As soon as the buyer and seller sign closing documents? As soon as the buyer brings their money to title? Let's expand this so you all can see it. And or the lender funds their loan as soon as the deed is recorded at the county recorder's office. True, false, the market conditions advisory should be incorporated as an addendum on line 38 of the purchase contract. True, false, a ring doorbell is a fixture that conveys with the property. True, false, an above ground hot tub is considered personal property that does not convey. I tried to make it a little easy on you this morning by doing mostly true, false. We have 42% participation. Where are the rest of you? There we go. Oh, wait. Well, then we had 52 and then it went to 48. Did somebody retract their statements? All right, let's see what we got. So true or false, earnest money must be at least 1% of the purchase price. That's false. Ultimately, it's completely negotiable. If somebody can tell me the weirdest thing that they have seen aside from actual money as earnest, I would be very interested to hear about it. I have heard of things. I've never personally bore witness to them. Livestock in certain areas were actually utilized, different leases, deeds to other homes, jewelry, all sorts of weird stuff I have heard about. I've just never actually seen it. So if one of you has a weird story, I'd love to hear about it. When does close of escrow occur? As soon as the buyer and seller sign closing documents? No, but ironically, that is what happens in a lot of states. So if you are working with clients, buyers from out of state, make sure that they're aware of that. That just because they signed, or as to the next one, just because they've paid their money does not mean that that house is theirs. They have to wait until the deed is actually recorded at the county recorder's office. And there is a very good chance that that is not the same day that they funded. True, false, the market conditions advisory should be incorporated as an addendum on line 38 of the purchase contract. This is false. As the name describes, this is not an addendum. Okay, and those lines 36 through 38, those are addenda incorporated. This is a great document, but it is an advisory. And realistically, it's a single party signature advisory. So this isn't something that you should be putting into the contract. Similarly, you shouldn't be incorporating agency disclosures or anything else that has a disclosure or an advisory name in it. This is exclusively for addenda. A Ring doorbell is a fixture that conveys with the property. That is true, unless otherwise negotiated. And an above ground spa is considered, or hot tub, is considered personal property that does not convey. That is also true. But interestingly enough, how somebody is moving a hot tub easily is really beyond me, or why anybody would want to do that is beyond me. You really risk the hot tub itself, the integrity of the structure, because there's a very good chance it won't survive the trip that you're trying to move it to. So just some common sense maybe should be applied there as opposed to what the contract says. But if you have a buyer who really, really wants that above ground hot tub, just be sure that you include that in the contract. All right, so this is not technically part of our purchase contract, but boy, is it a really good, helpful checklist for buyers. If you are not already going through this during your buyer consultation, you really should. Ironically, I think that this is the main thing that you should go through during your buyer consultation. I'm often asked what you should be talking about and what you should cover without making it overwhelming. And what a great point of reference this document serves as. So, attention buyer, you are entering into a legally binding agreement. That is all very bold and drawing your attention to it. So, it must be important that they understand that. And then some tips for them: read the entire contract before you sign it. Shocking, I know, but it should be done. Review the residential seller's property disclosure statement. Okay, those are the SPUDs. This information comes directly from the seller, or it better anyway. Investigate any blank spaces, unclear answers, or any other information that is important to you. And then ask questions should you have them. If something is missing or if you need additional clarification, your due diligence period is the time to ask. Review the inspection paragraph. It is, if important to you, hire a qualified general home inspector, heating, cooling inspector, mold inspector, pest inspector, pool inspector, roof inspector. Notice they didn't just say hire inspectors. They broke it down with pretty specific examples so that the buyer is aware just a home inspector may not be sufficient, and do plan on having these other professionals come to the property as well. And as we'll get into, at your expense. Verify square footage and verify the property is on sewer or septic. Most of those we know, but we have had some weird situations. So if that is of concern to our buyer, we definitely want them to check that out. Depending on the areas that you work, a sewer scope may also be very strongly recommended. I am noticing that many general home inspectors now offer this as an auxiliary service, which really just helps the fees to be not quite so exorbitant when the time comes. So just something to inquire with your home inspectors about. Confirm your ability to obtain insurance and insurability of the property during the inspection period with your insurance agent. I cannot stress this enough, and how often this is not done until we are at the tail end of the transaction and the lender says, hey, I need your copy of insurance so that we can set up your escrow account. The buyer hasn't even looked for homeowners insurance up to this point. And now, if there is any issue with the insurability of the property, this is not a means for them to get out and get their earnest money back. They would lose their earnest money and potentially be opening themselves up to a lawsuit for actual damages if those exceed the amount of the earnest money, simply because they didn't do what they needed to do when they needed to do it. So please make sure that they understand during those 10 days, they need to contact their homeowner's insurance company or multiple companies to start getting quotes and make sure that they're not going to have any issues. Apply for your home loan now if you have not done so already, and they better have done so already. Separate soapbox. And provide your lender with all requested information. It is your responsibility to make sure that you and your lender follow the timeline requirements in Section 2, and that you and your lender deliver the necessary funds to escrow in sufficient time to allow escrow to close on the agreed upon date. Otherwise, the seller may cancel the contract and you may be liable for damages. 6, read the title commitment within 5 days of receipt. Very few people do this, and yet it is a pretty critical component. We've got to make sure that there's no weird things, easements or encumbrances or liens that may ultimately prevent closing. We want to catch those and nip them in the bud as quickly as possible. Or even worse, they come to discover that the title commitment is reflecting a completely different parcel than the one that they're buying, and we really need to course correct to get that taken care of. Read the CC&Rs and all other governing documents within 5 days of receipt, especially if the home is in a homeowners association. Conduct a thorough pre-closing walkthrough. If the property is unacceptable, speak up, because after the closing may be too late. A quick note on that, you as agents may not conduct walkthroughs on behalf of your clients. This is a major liability situation. If they must, they can waive it, not ideal. They can send their home inspector back out to do one on their behalf, or they can assign a different proxy, maybe a friend, a kid, a neighbor, somebody else. But that person is not you. So please make sure that you are aware of that. You can obtain information through the buyer advisory, and then it gives the link for that. If you, as agents, do not have this link saved, where you can just readily send it out to prospective buyers, I would just save that. Well, either just so that you have kind of part of an entry or opening letter for your buyers, or just have that link on your actual browser tabs. So that way you can share that as the need arises. It's just, it updates automatically. So it's nice to have the live version, and the hyperlinks work if you share it online. If you just give them a printed copy, it tells them kind of where to go, but it doesn't actually give them the links to activate. They'd have to do that separately by typing it in. Remember, you are urged to consult with an attorney, inspectors, and experts of your choice in any area of interest or concern in the transaction. Be cautious about verbal representations, advertising claims, and information contained in a listing. Verify anything important to you. Okay, so just because the photos show the hot tub in the background doesn't mean that the hot tub conveys. Same thing with washer, dryer. Even if it says those things convey in the listing, you still must be sure that that is reflected on the purchase contract itself. And then we do have a wire fraud advisory, but this is already just giving a little tip right up front about wire transfer fraud. Beware of wiring instructions sent via email. Cyber criminals may hack email accounts and send emails with fake wiring instructions. Always independently confirm wiring instructions prior to wiring any money. Do not email or transmit documents that show bank account numbers or personal identification information. I know some of us are like, duh, but they just need that little bit of a reminder. A CYA tip for those of you in the younger bracket on here, that means cover your assets. Have your buyer initial next to every one of these checklist items. So as part of your consultation, whether it's electronic because you've done it via Zoom or you actually have them in front of you in person, have them initial next to all of these, just so you can indicate, hey, I did go through all of these different steps and they were made aware of what their responsibilities and duties were as part of the contract. I understand I talk very fast, so if you have questions about this section of the document, now is the time to ask.
Hey, Leah, I have a question.
Yeah.
Thanks for doing this, by the way.
My pleasure.
Really quick on number 5, where it says seller may cancel a contract and you may be liable for damages. Can you just give me an example of what damages would be?
Yeah, so damages mean any cost that the seller has actually incurred due to non-performance of the buyer. So generally speaking, and this won't be today, but we'll get to this. Generally speaking, the earnest money is sufficient for damages. However, there are cases where that may not be. They elected to accept less earnest money than perhaps they should have. And their actual damages, they've had holding costs for 2 months because of delays in closing. They've already paid movers. They already entered into a lease for another home that they are currently paying on. All of these different things may have exceeded that $2,000 earnest deposit. So they want to actually pursue real damages. Let's say in that case, it was $12,000. The contract says, hey, the seller may accept earnest money as their sole right to damages, but not that they have to. So the seller in that situation could forego the earnest money, tell title, I'm going to pursue this separately because I want more than the earnest money is going to cover.
Thank you.
My pleasure. Anybody else? And thank you for breaking the barrier so now others will be more comfortable in asking their questions going forward. All right, the PC itself. So let's go ahead and start with, in case you weren't aware, this was most recently updated this month. So on the 1st of February, they released the updated version. There really weren't major material changes. The biggest one was, in essence, just indicating who's being compensated. We'll get to that in the third session of this class because it has to comply with the departmental ADRE requirements that were put forth on December 13th. So that was the reason for the most recent change. But as always, make sure that you are using the most recent version. Otherwise, you might have some hiccups with your E&O coverage. And as a reminder, the pre-printed portion of this form has been drafted by the Arizona Association of Realtors. Any change in the pre-printed language of this form must be made in a prominent manner. No representations are made as to the legal validity, adequacy, and/or effects of any provision, including tax consequences thereof. If you desire legal, tax, or other professional advice, please consult your attorney, tax advisor, or professional consultant. Very quick note on the changes must be made in a prominent manner because a gentleman who's been doing this for 40 years thought that he would school me yesterday on why we couldn't make a modification directly to the purchase contract. And to which I replied, that's actually not accurate. If you read this little section up above, while not ideal, there are certain situations where we just missed something. And as opposed to doing an entirely new contract, and in some cases, even an addendum doesn't make sense, like a box checked, we can add that, and then we can just have both parties initial by the change. It's really not the end of the world. That would classify as a prominent manner. But that's what it's referring to, that what they don't want is some of you get crafty with your PDF writing programs and you start modifying documents. Some of you may have been in this business long enough to remember this. There was actually a very high profile team who, during the short sale days, modified the language in the HOA addendum to specify that the buyer shall pay for the disclosure fee. It was not caught until they had closed 100 or 200 short sales. It was insanity. So not only, which by the way, that's statute. So not only did they violate the law because statute says that the disclosure fee must be paid by the seller, but they went in and they actually modified a copywritten and trademark document to reflect a completely different sentence. I don't know what that ended up settling for, but if you imagine $400 disclosure fees times 1 to 200 short sales, yeah, those are adding up pretty fast. So that is what they are looking to avoid. So section 1, the property itself. So we've got the buyer, we've got the seller. These should be as their name will or does appear on the deed. There are certain situations where we may not fully know because it's a weird LLC or a trust, or we're getting some conflicting information, or it's not outlined on Monsoon very accurately. If that happens, don't put anything on line 2. Just check that box or as identified in section 9C. Okay, that's going to be kind of the area where we can step away from that in case we're not 100% sure. Worst case, you get it wrong and the other side needs to counter or send over an addendum with the correct name. So it's not the end of the world. Buyer agrees to buy and seller agrees to sell the real property with all improvements, fixtures, and appurtenances thereon or incidental thereto, plus the personal property described herein, collectively the premises. The address, the assessor's number, the city, the county, the zip code, and the legal description. For those of you who aren't aware, that legal description is actually the most critical part of the property description, especially in land, but even for residential. That must be in there. I too often see contracts coming through where those lines are blank. I won't say that you have an invalid contract. You have an arguable contract if, God forbid, there is ever an issue with the actual premises, especially if an address is inputted incorrectly or there was a misnumbering on the assessor's number. All of these things have happened. But please, please know that the legal description is the most critical part of this, and that must be included. If it does not already include the lot number, please include that. It just makes it easier for the title company. Math. The thing that so many of you are really not so good at, full purchase price as outlined below. Now, to me, I think that's clear that that means that lines 11 through 13 should equal line 10. There are a couple of exceptions, which I will cover. So whatever that purchase price is, the next one is earnest money. So I know we said, hey, it is negotiable. And ultimately, while 1% used to be very common, I don't know that that is anymore. But this is a Leah tip. Talk to your sellers about the expense that they will have by having their home off the market for 30, 45, 60 days. And that earnest money should cover those expenses. We know that there is no guarantee that they're going to get the earnest money, but if we are in a position where they will, it may as well be worth their while. So if we are looking at a $700,000 house, $1,000 in earnest money would not be sufficient for me. I would be probably looking at somewhere in the realm of $5,000 to $10,000 in that case. Again, just a recommendation. And then assuming that this is going to be a traditional loan that is not 100% financing, so conventional, FHA, any of those, next to earnest money, I would put applied toward down payment. Okay, we're going to have all of these line up. Line 12 then would be whatever remaining down payment there is. So $500,000 house, 20% down payment is $100,000. We're doing $10,000 earnest money. $90,000 is your remaining down payment. If this is not being financed, if this is cash, then you would simply put on that line cash at COE. Just break it down. If this is a VA or USDA loan, those have 0% down payment options, and most of those buyers will take advantage of that. That being said, your earnest money would not be applied to a down payment in that case. So what I generally recommend for VA or USDA loans is just write a little note that it will be applied to their closing costs or refunded to buyer at COE. Because if they're not going to have a down payment, but they're also getting their closing costs paid, I don't want that applied to their closing costs. So I want them to just be refunded at close of escrow. And anything that they've put into escrow, they can get out of escrow. So it's not a problem to write this in there. All right, so now assuming that it is not VA, it is not USDA, and it is not cash, we have line 13, which is going to be the new loan balance. So that will be the new loan secured by buyer. You can say new FHA loan, new conventional loan, whatever that is, that's your loan amount secured by buyer. And again, then 11, 12, and 13 should equal 10. To me, this is not a material concern. If somebody, I don't know that I've ever checked somebody else's math on this, to be quite honest, because at the end of the day, it doesn't really matter. The things that I'm looking for are what are the purchase price and what are the earnest money amounts. That as a seller's agent, that's what I'm most concerned about. So if their math is a little off, don't sweat it. Let's proceed. Earnest money is in the form of a personal check, a wire transfer, or other. Okay, remember I mentioned, hey, it could be something kind of wonky. I've seen it. Again, if any of you have a situation, I'd love to hear about it. Upon acceptance of this offer, the earnest money, if any, and there better be some, because really you don't have a valid contract without consideration. Now, I will say that that consideration, again, does not have to be actual money. It doesn't have to be cash or currency. It could be something else, in which case it wouldn't likely be deposited with an escrow company. It may be held in a different fashion. But I want you to be sure there are no circumstances under which I would deposit earnest money into a broker's trust account. It should always go to the escrow company. So no matter what, please make sure that you are marking the escrow company box on this.
Leah,
Yes.
good morning. Quick question for
morning.
you.
Yeah.
Going back to line 11, the earnest money, why do you have to specify that the earnest money is applied towards the down payment?
I just do that for practical purposes because those are serving as instructions to the title company so that they know how to handle it.
Isn't that a given?
Not necessarily. So again, if you have a VA or a USDA buyer, it wouldn't go towards a down payment because they don't have one. If they are getting a gift of earnest money, that gift may be refunded and they would come in with separate funds at close of escrow.
Interesting. Thank you.
Yeah, uncommon, right? I agree with you, Katya, that realistically that that would be a given in most cases. Like 99% of the time, we know how that's going to be applied, but there are those just weirdly random ones. So there is a reason that that line exists after earnest money, and it's really just for application thereof. I do have people who, and this would be okay as well, I don't know that it's necessarily needed, where they are designating the time frame if it is outside of upon contract acceptance. They are maybe designating on that line shall be deposited by buyer within 3 business days of contract acceptance. That would be okay as well. Realistically, I think I would put that in the additional terms, not on this line, but that's just how they're using it.
Would you recommend that? The
Giving
time
myself
frame?
additional time to deposit earnest money?
Mm-hmm.
I guess it depends on who I represent, but no, not really. I like things to be done as expeditiously as possible, and if they're acting in good faith, there's no reason that they can't get the earnest money deposited the next business day.
Got it. Thank you.
Of course. If this is an all cash sale, a letter of credit or a source of funds from a financial institution documenting the availability of funds to close escrow is attached here too. I don't remember when this change was made to the contract. It may have been 2018, but I am forever grateful because there were constantly arguments regarding what documentation was necessary to evidence a cash sale and when it had to be provided. So we've now taken the stance that very similarly to the prequel, it's included. It is part of this actual offer so that we can see everything at once. If they will not have that letter and they still want to submit an offer, they may do so. You're just going to have to modify in Section 8 of the purchase contract when that letter would be provided. All right, little soapbox.
Oh, sorry. I have a quick question about that. So if they don't have an official letter and they provide a bank statement with their accounts, blacked out, you can accept that, but you would put in the additional lines that it's a bank statement. Is that correct?
You wouldn't even have to do that. So that source of funds. So a bank statement's totally fine. In many ways, honestly, I think I'd prefer that over just some generic letter. A letter's easy to write. I could do one of those as the president of some unknown bank.
Okay, as long as it's like 30 days. If you're representing the seller, you want something the most current, obviously.
Yeah, exactly. So what we're looking for is the date. The sooner the better, of course. But yes, ideally within 30 days. I want to see their most recent statement. Let me put it that way, which means it should be within 30 days. And the names have to match, and then the dollar amount. That's really what I'm looking for. On that note, as I just kind of alluded to, it is very easy, and I understand that this is fraud, right? I understand this. However, I don't put anything above anybody anymore. I've just learned my lesson. I don't know that the majority of these documents that we're seeing when it comes to these letters from a financial institution, honestly, even bank statements in some cases, are worth the paper they're written on. So while, yes, it's nice to know that they are acting in accordance with the contract and they are providing that, I don't know that that letter is the end all be all. Now, why somebody would generate a completely fraudulent letter, I don't know, but I have seen it. Many of you who were on the forum probably saw over time, people were sharing samples of, look at what I got today, and here's how you can tell that this has been a documented or a modified document. Okay, they've altered it in some way, shape, or form. Again, I don't know what the expected end game is there unless there's some deed fraud relation that it's tied to, but even then, you're not going to have the funds. So I don't know what the point of that would be. So my kind of general stance is I don't know, again, that that's worth the paper it's written on, but I do think that if it is a cash buyer, most of them are acting in good faith and they're just proving, yes, I do have the funds to do this. The ones that crack me up is it's not all in one account because they're smart and they understand how FDIC regulations work. So they're going to send you like 13 different documents to serve as proof of funds because they're actually going to pool from various accounts that they have. And all of that is okay. Like I said, and Anne's question was great, that really we're looking for the name matches, the amounts available, and then the date of those documents. Any other questions about this first section?
I just kind of have a question in general. If you are representing the seller and you get the old version of the purchase contract, what would you say to that buyer's agent?
Check your templates and fix them. For most of you, this should not ever be a problem because you're using online transaction desk or SkySlope forms or something similar where all of those updates are made automatically, so you don't have to worry about this even. depending on what it was. Now, if they have the previous version, which was 2024, I think, I know what those changes were, so I could just counter to include those lines that were changed on a counter offer. But quite honestly, I think I would tell them, hey, chat with your broker because this is not the most recent version of the contract and we need that used.
Okay, thank you.
You're welcome. That does tie into kind of a different issue, which is, do I still have in essence, an offer that I need to present? And the answer to that is yes. But in doing so, I would have to explain to my client, hey, this isn't the most recent version. These are the changes that were made. We can counter this back or we can ask them to rewrite. But ultimately, we need to account for these things. But that requires a lot of knowledge on everybody's behalf. But for statute, yeah, you would have to provide a copy or discuss that offer that was actually made. So I know, again, that ties into other things.
Leah?
Yes.
In the case of the cash buyer, let's say you don't catch it right away. And is it like any other typical offer that something happens and then the seller just gets the earnest monies at the end?
I don't know what you're referring to. In the case of a cash buyer, what happened?
If you don't catch, oh, I'm sorry. If you don't catch a fraudulent cash buyer, would it be in the case, like, let's say you don't catch it and just goes through the whole transaction, at the very end, would it be like something happened and the seller gets the earnest monies to take care of whatever happened?
Yeah.
I mean, how do you deal with that?
If we can, in essence, prove that it was in fact a fraudulent letter written from the onset, difficult, not impossible, but difficult, then yeah, we right off the bat, that's an immediate breach of contract. They failed to disclose material information, which would then ultimately mean that the seller would get the earnest money. However, for anything else, like we're not aware of what's going on, all we know is that they're not closing, then we would have to follow the proper protocol by curing first. And then upon expiration of that cure notice where they still haven't closed, then our seller would be subject to collecting the earnest money.
Okay, thank you.
You're welcome. Anything else? Okay, moving on. Close of escrow, we had this one on our little poll, shall occur when the deed is recorded at the appropriate county recorder's office. Buyer and seller shall comply with all terms and conditions of this contract, execute and deliver to escrow company all closing documents, and perform all other acts necessary in sufficient time to allow COE to occur on a specific date. If escrow company or recorder's office is closed on the COE date, COE shall occur on the next day that both are open for business. Okay, so that's not a curable offense. If somebody put in a Saturday or a holiday for closing, nobody caught it, and here we go. The seller can't cure the buyer because we can't close on Christmas Day. They have until the next business day to be able to perform before this would be a curable offense. And again, the deed is recorded. That's when close of escrow actually occurs. Period. Nothing to do with funding or signing. Buyer shall deliver to escrow company a cashier's check, wired funds, or other immediately available funds to pay any down payment, additional deposits, or buyer's closing costs, and instruct the lender, if applicable, to deliver immediately available funds to escrow company in a sufficient amount and in sufficient time to allow COE to occur on the COE date. It's always so funny to me because I can tell when the attorneys for AAR have actually written these clauses as opposed to just the risk management committee. And that's definitely one of them. But all that's saying is, buyer, you better have your shit together and your funds ready to go. That's what that clause is saying. I did recently have a situation where they spent the down payment, and yeah, that's a problem. So they had to figure out how to correct that problem really fast. Buyer acknowledges that failure to pay the required closing funds by the scheduled COE, if not cured after a cure notice is delivered pursuant to Section 7A, shall be construed as a material breach of this contract, and the earnest money shall be subject to forfeiture. Okay, so again, that's reminding them, hey, we still have this cure period, but depending on the circumstances, chances are that you will lose your earnest money if you do not have your funds to close, as they should. And all funds are to be in U.S. currency. Yes, we think that again would be common sense. However, we had a case where Canadian dollars were involved, and the person from Canada didn't believe that they should have to pay in U.S. funds when their Canadian dollar started to lose value. So that's why that's in there now. Seller shall deliver possession, occupancy, existing keys and or means to operate all locks, mailbox, security system alarms, and all common area facilities to buyer at COE or blank. I do not want you to write a different date or post possession on that line and consider the job done. Talk to your broker if pre or post possession will potentially apply, as many of us have our own supplemental documents to assist with that will cover way more than you could possibly think. My post possession agreement is 4 pages long. So it is not just a, hey, the seller gets to stay in the property for a week after closing. No, not sufficient. And we definitely need to make sure that both parties are protected in those situations. So please don't put some other date or information on there. If legitimately we're doing some sort of pre or post possession, that needs to be by separate agreement. Brokers recommend that the parties seek independent counsel from insurance, legal, tax, and accounting professionals regarding the risks of pre and post possession of the premises, which those forms include all of that legal mumbo jumbo as well. I highlighted the existing keys because, again, this is often an argument I see. If the seller is someone who has only ever used their keypad through their vehicle or through their phone, they may not have garage remotes. They may not have additional keys if they have a smart pad on their door. So they are not required to acquire these things for your buyer. They are only required to provide those things which they already have. And then, as we discussed, addenda incorporated. Additional clause, buyer contingency, domestic water well, HOA, lead-based paint, loan assumption, on-site wastewater, that's your septic. Seller compensation, hopefully most of you are including that. Don't forget, if you want to get paid and your buyer's not willing to do it. Seller financing, short sale, solar addendum, or other. So other might be, I know in the Sun Cities, for example, we have the adult community addendum. You might have an REO addendum. We're starting to see those a little more frequently, or some sort of seller addendum. So those are typically what we would put on that other line. Again, it's not for any advisories or single party documents. Questions before I move on? Okay. Fixtures and personal property, the bane of my existence. For purposes of this contract, fixtures shall mean property attached or affixed to the premises, which doesn't make as much sense as you think it makes when you're arguing about a very specific item. Seller agrees that all existing, again, we're using that key phrase, fixtures on the premises, personal property specified herein, and means to operate fixtures and property, i.e. remote controls, shall convey in the sale, including the following. And then we have this laundry list of items. Built-in appliances, ceiling fans or remotes, central vacuum hose, attachments. I'm not going to go through all of these. What I want you to be sure you are doing is when you are doing your listing presentations with your seller, make sure, and yes, this is repeated in the ER, although I haven't actually compared these side by side to verify that everything is identical. I would assume it is, but we know what they say about assuming. Let's make sure we have this contract list available and we go through with our sellers. These are the things that will convey. So if you have something that falls under any of these categories, remove it now. So that way we're not arguing about it after the fact. If anything could potentially be one of these things, remove it now so that we're not arguing about it after the fact. Usually where the kind of litmus test, as I refer to it, falls in is not just how something's attached, but it's what's its intended purpose. And if its intended purpose is to serve some sort of, again, purpose, I hate to reuse that word, but specific to the property, then it will be a fixture, no matter how it's attached. So these are the kinds of things where we don't want to get a legal team involved, but if there is any question, just remove it so that we don't get that far. If owned by the seller, the following items are also included in this sale. So your solar systems, your in-ground spa, hot tub, in-ground spa, hot tub. I would love to know how somebody would remove that. That's fine. It's neither here nor there. Including any mechanical or other cleaning systems, security and or fire systems and or alarms, water purification systems, water softeners. A lot of times people want to take their water softeners, which is fine, but again, then have it removed in advance of listing so we don't have an argument. And then additional existing personal property included in the sale. So if the buyers want the fridge, washer, dryer, even if it was already stated in the listing that these items convey, that must be handled through the purchase contract. So they still must mark these boxes and provide a brief description. Any description will do. I know some people go absolutely above and beyond, and they've got serial numbers and all sorts of things. That's fantastic if you do that and can think of that. However, just describing, hey, it's a side-by-side stainless steel Whirlpool is definitely sufficient. That's just what we're looking for. Your above-ground spa or hot tub, including equipment, covers, or any other mechanical or cleaning systems. Again, brief description if applicable. Other personal property not otherwise addressed, and they gave you 2 lines for this. This is not intended to be used with a fully furnished home purchase. This would be, hey, they really liked the swing set in the backyard or the pool table inside, maybe some of the patio furniture. That's where you could put those on these lines. And that's okay. Even if there's a loan involved, if it's just 1 or 2 personal property items, that is okay. And then this line was added because so many lenders were saying, hey, we need to have it specified that the personal property conveys at no monetary value. So we're like, hey, let's take care of that for you. Additional existing personal property included shall not be considered part of the premises and shall be transferred with no monetary value and free and clear of all liens and encumbrances. So again, we just try to eliminate some of those concerns that lenders had. Leased items shall not be included in this sale. Seller shall deliver notice of all leased items within 3 days after contract acceptance. Buyer shall provide notice of any leased items disapproved within the inspection period or 5 days after receipt of the notice, whichever is later. So solar is probably the most common, that if that wasn't already disclosed and if they haven't already provided that documentation, the seller would need to do so within 3 days of contract acceptance. But we have had things where pool equipment, even the water softeners or water purification systems, there are other things that potentially could be leased. So we just want to make sure that the seller is disclosing those items as quickly as possible so that we don't, again, bump into issues where we think something's conveying that it's not. If this is an all cash sale, Section 2 does not apply. Go to Section 3. And we will cover a little bit of that as to why we need to make sure we understand if you have an all cash sale, if this is a cash buyer, you should not be marking anything in Section 2 because those things do not apply. Questions?
Hi, Leah. Good morning.
Good morning.
I have a question about the 55 line. When do
Yes.
you mark refrigerator, washer, or dryer, they send into addendum. We need to do that?
Sorry, I don't know what you mean by they send addendum.
I mean, on the clause. It's in the clause. When do you mark refrigerator, washer, or dryer? And automatic, they send them to need to make on a clause. And I don't know why.
I don't know why either.
Yeah, because every time when I mark it, they send me to this. They say, "Do you need to make this close?" And I say, "Oh, I don't know." So I decided not to mark.
I don't know why that would be required. Like this is marking the boxes and providing a brief description is sufficient. Nothing further should be needed.
Well, I know marker is fine. I go to sign in, but it's a marker they need to make the close and they don't allow me to go to send them to the signature.
Oh, you're talking about like there's actually it's not one of the parties. This is in the signing software that you're having issues. Am I understanding correctly?
Yeah.
Okay. That's a tech issue. The next time you see me, show me what you're talking about and let me see if I can figure out why this is being a problem.
Okay. Thank you.
You're welcome. Anybody else?
Yeah, I've got a question.
Yeah.
For the leased part, line 65,
Mhm.
if an assumable loan comes up and they're trying to get you to, or your client to take over their solar, even though the solar's leased.
Mhm. That's going to be handled through a separate addendum.
Okay.
So the leased items, this is a disclosure of what will not convey. So a situation where solar wouldn't convey, and to your point, Austin, the majority of the time it will, right? Like nobody's removing their solar panels,
Right.
but they could. So some original agreements with solar said, hey, we will allow the current homeowners to move their solar system to a new house one time free of charge. So there is a possibility of that happening. It's less likely. So in that situation, the leased items will convey, so to speak, but they're conveying with the assumption, and the assumption terms are all going to be handled through the solar addendum.
Okay, perfect. Thank you.
You're welcome. Anything else?
Hey, Leah, I had a quick question.
Yeah.
Back to the prepossession.
Mhm.
Post-possession, is it just okay if we don't put a date? We just put per pre-post possession agreement in there?
So you wouldn't need to write anything in there.
Okay.
My recommendation is don't touch the contract when it comes to pre and post possessions. Have those signed separately.
Okay. So, but am I putting just like, just to let them know that there is going to be a post or pre? Do I put like an under other pre-post possession agreement?
So I wouldn't, and I wouldn't potentially because of lending, but really we want to keep that as separate as possible. I think to your question, in essence, if that is a critical part of this offer, then yes, we may have to, and I don't know that I would do it on addenda incorporated because it's really not an addendum. But we may have to indicate in the additional terms that a post-possession agreement is incorporated herein, or a pre-possession agreement is incorporated herein.
Oh, okay.
I would only do that if that pre or post-possession is material to one of the parties, meaning that they will not move forward with an offer unless that is included.
Okay, got it. Thank you.
You're welcome. Anybody else? All right. Your favorite time? No. Sorry, guys, my thing is being kind of wonky today. I'm trying to get you a poll so that you can show me how much you know about all these things now. Okay, poll 2. True or false, the contract requires that buyer's loan documents are at title 3 days prior to COE. True or false, the buyer or buyer's lender must provide an LSU anytime the seller requests one. And number 3, the buyer's offer reflected a conventional loan with 20% down. The buyer has now decided to obtain FHA financing and put 3.5% down. Does the change require an addendum? Yes, no, or it depends. Five seconds.
Leah,
Yes.
regarding the post possession, what if they do a post possession, but it's free of charge? Would that affect the lending side? And I mean, I'm guessing no.
Potentially, because it has nothing to do with the finances. Actually, it has to do with the timing of occupancy restrictions for the loan.
Oh,
Yeah,
thank
so
you.
for some people that won't matter at all. And if it's less than 30 days, you definitely won't have a problem. If it's less than 60 days, most of the time you're okay. But I mean, we've had some people that are looking at post-possession agreements for 6 months. In that case, realistically, you need a lease. But that is a problem for the lender, again, because of occupancy.
Okay, so if it's like a week or two, doesn't matter.
Now, you're probably fine. I wouldn't worry about those.
Okay, thank you.
You're welcome. All right, true or false, the contract requires that buyer's loan documents are at title 3 days prior to COE. That's mostly false, but I think I know why many of you put true. So that is an option, but it's not actually a contractual requirement. As we'll go through in the financing section, it gives the buyer a couple of options for what they need to have completed 3 days prior to COE, and its loan documents are not one of those. True or false, the buyer or buyer's lender must provide an LSU anytime the seller requests one. That is true. This contract already specifies 10 days after contract acceptance, but then it also says or upon request from seller or seller's agent. And the buyer's offer reflected a conventional loan with 20% down. The buyer has now decided to obtain FHA financing and put 3.5% down. Does the change require an addendum? The correct answer is it depends. And I would love for somebody to unmute themselves and tell me, what does it depend on?
if it affects the seller's ability in some fashion.
Tony, a lender can't be cheating on here
You're-
by knowing what these things are.
I was thinking that. I was Tony, you're cheating. You know the answer.
Hey, listen, knowing the answer is not cheating. It just means he's smarter than the rest of you.
Yeah, I was gonna just say if it changes anything materially for the seller, like if it changes the close of escrow date or anything like that, but other than
And
that, no.
Yeah, that's 100% correct. So the only time an addendum is needed is if it adversely affects the seller, meaning that their costs are going to increase or that the close of escrow date is going to be delayed, something to that effect. Otherwise, it's simply notice, which we'll discuss. Well done, guys. Well done. Good teamwork.
I look like a stop sign now. I'm so red.
I didn't even say anything that embarrassing this time. Just wait. There's time. There's time and there's 3 sessions. All right. Financing. Pre-qualification. An AAR pre-qualification form is attached here to and incorporated herein by reference. Oh, wait, Nika?
I have a question. This is Veronica. Am I showing up as Nika?
You are.
That's
You're
strange.
showing up as Shanika Average.
Oh, wow. Oh, okay. So I have a question. So if the buyer does change to FHA financing, can the seller pull out of the contract in that instance?
Nope.
If they change? No. Okay.
No, and that's a great follow-up question to that because a lot of them seem to think that they can. And I will be honest, especially in the wake of a really strong seller's market, which we're not in right now, by the way, but when we were in like 2021, what amazing bait and switch option was available for somebody to completely change what they were, their offer was accepted based on this and this and that. And then they're like, oh, just kidding. Here's notice. We're going to change it. But legally, they can do so. The contract gives them that right as long as it doesn't adversely affect the seller. All right, loan contingency. Buyer's obligation to complete the sale is contingent upon buyer obtaining loan approval without prior to document PTD, sometimes PTSD, that's what it feels like, conditions no later than 3 days prior to the close of escrow date for the loan described in the AAR loan status update form or the AAR pre-qual form, whichever is delivered later. Which is kind of weird. I would assume the LSU is always delivered later, but who knows? I stop asking questions sometimes. So here is for those of you who said, hey, loan docs have to be at title at least 3 days prior to closing. Not totally true because these are the options, okay? No later than 3 days prior to the close of escrow date, buyer shall either sign all loan documents or deliver to seller or escrow company notice of loan approval without PTD conditions and dates of receipt of closing disclosures from lender, or deliver to seller or escrow company notice of inability to obtain loan approval without PTD conditions. So it's that middle, that sandwiched or that quite honestly is, in my experience, way more common than actually having the loan docs at title 3 days in advance. And they wouldn't even have to necessarily be at title. That would be kind of weird. But I mean, I could see somebody making an argument where I actually signed all my loan documents with my lender and then sent them over to the title company. That's why we want to be cautious. We see weird stuff, but that middle one is the most common. So it's not that the documents have to be at title 3 days prior, because very often it's, hey, we have what we need, but the lender is sending those docs the night before or the morning of closing and having everything dated accordingly. So just make sure you understand you can't necessarily cure for that for the loan docs if ultimately that middle section has been complied with. Unfulfilled loan contingency. This contract shall be canceled and buyer shall be entitled to return of the earnest money if, after diligent and good faith effort, and what a fun argument that is, buyer is unable to obtain loan approval without PTD conditions and delivers notice of inability to obtain loan approval no later than 3 days prior to the close of escrow date. Except, if buyer fails to deliver such notice, seller may issue a cure notice to buyer as required by Section 7A, and in the event of buyer's breach, seller shall be entitled to the earnest money pursuant to Section 7B. You know what? I try to hold out as long as I could. 7B, if prior to expiration of any cure period buyer delivers notice, blah, 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 shall be entitled to return of the earnest money. Buyer acknowledges that prepaid items paid separately from the earnest money are not refundable. Okay, so any inspections, any appraisals, they are not getting that money back. The most frustrating part of our contracts to me is our cure period. I have to be honest. And that's because it's such an anomaly in the grand scheme of things. Anybody who has come from other states is like, what the hell is a cure period? If they didn't comply by the designated date, they're in breach. Oh no, my friends, not in Arizona. They are only in potential breach. Am I going to date myself if I'm like, it's only mostly dead? For those of you who watch movies, you'll know what I'm talking about. That's kind of how I feel about our cure period. So when these, God love them, these sellers, especially those who don't fully understand what this means, they will issue a cure notice. They're like, well, when's the last date that we'll know for sure if the buyer can perform or not? After closing? I mean, it's not even by the close of escrow date. There are times where we won't know if the buyer will perform or not until closing has come and gone. And now we have to cure them for failure to close, which gives them at least 3 more days to close. Because if you bumped into a holiday weekend or Thanksgiving or Christmas, it could be a week in some of those cases before the buyer is legally required to close. That is horrible. I don't know. I'm kind of on a rampage about this to the point where I waver. I'm like, what if we just removed Section A from the purchase contract? What if I just countered and said no cure periods shall ever be required? If you don't perform by the time you're supposed to perform, it's an immediate breach and you're done and we're keeping your earnest money. Ask me again tomorrow. I may feel differently. Perimenopause is a whole thing where I do get very irritated. But that's my hot topic for today. I'm not even going to give you the chance to perform. You had 30 fucking days to do it, and if you didn't comply by then, I'm not giving you an extra 3. End of story. But you can understand where this is really difficult to explain to sellers, especially because they've scheduled movers. They have other homes on the line potentially, and these delays are going to be problematic. So aside from removing with the cure period, which I'm not totally against, I might have a couple of other suggestions for you as well, just to try to keep this moving forward so we don't have these last minute delays. Interest rate necessary funds. Buyer agrees that the inability to obtain loan approval due to the failure to lock the interest rate and points by separate written agreement with the lender, or the failure to have the down payment or other funds due from buyer necessary to obtain the loan approval without conditions and close this transaction is not an unfulfilled loan contingency. I want you to make a note of this right now, and it's in relation to the LSU and the pre-qual. I want to see a specific interest rate on those forms, because how will I know if the reason that they're backing out is related to the interest rate lock or not? If their documents, their pre-qual and their LSU say market rate, well, what does that mean? Are they legitimately approved for 8%, or are they approved for what market rate is right this minute? I'm very, very passionate about this because I think a lot of buyers have gotten out on a technicality because they failed to lock their interest rate. They can no longer afford the payment. They're getting a loan denial, but it all stemmed from this clause, and they should not have gotten their earnest money back. So please make sure that there is an actual percentage in those pre-qual forms and not just MKT or whatever other nonsense people put in there.
Hey, Leah.
Yes.
So what do you do when the lender pushes back on putting, so I have the listing and I receive an offer where the lender has not specified an interest rate and they are pushing back on putting an interest rate there. Do you just reject the offer?
I mean, potentially, or counter it back that the buyer's required to. So keep in mind, we default to the lender needing to fill this information in. But quite honestly, the LSU and the pre-qual, those are contract documents. There is nothing that would preclude a buyer from completing those themselves. Not ideal and probably not what we want. But there is nothing that would preclude a buyer from putting their own max interest rate on that line if they want to move forward with the house.
So if I've had a conversation with the buyer's agent and they said, well, the lender doesn't want to put a number in there, but they said the interest rate is going to be X. So you just put that in the counter to
That's
say,
what I would do.
Line such and such of the pre-qual to be.
Potentially. So here's the flip side to this, right? Because we represent the seller. So I'm like, well, do I want to give the buyers a cap? I mean, kind of, because I want to know if they're going to get the earnest money at the end of the day, but maybe also not necessarily, because why are we implementing that if ultimately I can prove at the end of the day that they didn't have a cap and that's why they're backing out? I get the question. I'm definitely more in the let's set that cap now. And yes, you could absolutely counter back with that just to set the standard for it. I don't think there's a great solution to this problem, unfortunately.
Right. Okay.
And let me put it this way too, in this market, I don't know that I'd necessarily be blowing a deal over failure to have an interest rate in the prequal. I think we just take it as it comes and hope for the best instead of turning down a buyer over something that may or may not materialize into a problem down the road. All right, loan status update. Buyer shall deliver to seller the LSU with at minimum lines 1 through 40 completed, describing the current status of the buyer's proposed loan within 10 days after contract acceptance, and instruct lender to provide an updated LSU to brokers and seller upon request. Okay, I think we understand all of that. If the seller asks for it, we're going to provide it. Now, as sellers, don't be a-holes, okay? You do not need an LSU every other day. I promise you, you do not. However, once a week is probably pretty common and would be sufficient. So if you don't already have a lender on the other side who has that in schedule where they know and they have already agreed to send it out weekly, that would be my target, that at least once a week I'm seeing that.
Is that a curable item?
It sure is. Yeah, and it's not just the 10 days. So that's an easy cure, right? If we don't have it at 10 days, we can issue a cure. But again, I'm kind of don't necessarily jump to a cure, even though I think they're love notes. Let's ask for it first. And then if they still haven't provided it by the next day, then we would cure. But anytime, kind of the same process, anytime that we're requesting it, if I've requested it today and I still don't have it tomorrow, then I would be able to cure for it. Any other questions on this part? All right, so I told you that I would try to give you some pointers for eliminating some of these concerns. And one of my pro tips is this section 2B where it talks about no later than 3 days, these things shall happen. Quite honestly, bare minimum, I would do 5 and maybe 7 days in advance. So you can include that in a counter, or you could specify to a buyer's agent to include that in their offer, where those actions must occur 5, 6, 7, however many days prior to close of escrow. So that way we're not up against this super tight window for closing. Loan application, unless previously completed within 3 days after contract acceptance, buyer shall provide lender with buyer's name, income, social security number, premises address, estimate of value of the premises, and mortgage loan amount sought, and grant lender permission to access buyer's tri-merged residential credit report. I really hope the majority of this has been done in advance, and that's the prequel that's being delivered. However, check with your lender. One of the parts of the application, as you can see, is premises address. Well, they don't have a premises address until they're ready to submit an offer, right? So that means they don't necessarily have a complete application unless, Tony, you are working with a lender who is able to do a TBD option on the loan application, so they can legitimately get a real far way into the process without an actual address being designated. So just check with your lenders and make sure that that is something that they have available. Or if you are representing the seller, feel free to call and ask the lender if they have that option or if they have already done so. Mm-hmm. You're welcome for that shout out.
Thank you. TBD is something we do all day long.
Excellent. Excellent. Loan processing during escrow. Within 10 days after receipt of the loan estimate, or the LE, for those of you who like acronyms, buyer shall provide lender with a notice of intent to proceed with the loan transaction in a manner satisfactory to lender, and provide to lender all requested signed disclosures and the documentation listed in the LSU at lines 32 through 35. Buyer agrees to diligently work to obtain the loan and will promptly provide the lender with all additional documentation requested. Tell you what, lenders will tell you all sorts of things because they don't want to be the one to get thrown under the bus. So if there were some delays and we're kind of questioning it, we call the lender and they're like, you know, I asked for this a week ago and they still haven't provided it. Fabulous. We can issue a cure notice for this. So if we have some buyers who are dragging their feet on providing documentation that's been requested, this is a curable offense, just something to keep in your back pocket. Type of financing, that doesn't really matter because it can change. Conventional, FHA, VA, USDA, assumption, seller carryback, or other. Other might be hard money. So just a point of clarification. Hard money is not cash. It is financing. So please make sure that if you have a hard money loan involved, that is where you are marking it. Do not treat it as cash because it is not. If financing is to be other than new financing, see attached addendum, which is kind of interesting how they have that, because realistically that would be an assumption. So I don't know why we have that marked plus, but whatever. That's referring to you would have a loan assumption addendum. Loan costs. All costs of obtaining the loan shall be paid by buyer unless otherwise provided for herein, which takes us to our seller concessions, if any. In addition to the other costs seller has agreed to pay herein, seller shall credit buyer X% of the purchase price, or not both, don't confuse this, or a flat dollar amount for seller concessions. The seller concessions may be used for any buyer fee, cost, charge, broker compensation, or expenditure to the extent allowed by buyer's lender. I'm seeing some offers come through where the buyer's agent has included, in essence, an identical clause in the additional terms. And I think it's because they took my class maybe 5 years ago before this spelled out that, hey, in essence, the buyer can use it towards anything they want as long as their lender approves. So you don't need to create additional language for this. You no longer need to have concession language. If you don't even know what I'm talking about, excellent. Work with what you got. This is the only place that concessions need to appear. Changes. Buyer shall immediately notify seller of any changes in the loan program, financing terms, or lender described in the pre-qualification form attached hereto, or LSU provided within 10 days after contract acceptance, and shall only make any such changes without the prior written consent of seller if such changes do not adversely affect buyer's ability to obtain loan approval without PTD conditions, increase the seller's closing costs, or delay COE. Okay, so that's what we were talking about, why we don't need an addendum necessarily. They can make those changes, and all they have to do is provide notice, which is on the notice disclosure form. It is only signed by the buyer in that case, and it would indicate that they are changing their financing parameters. That's it. Here is the frustrating part for me. This early on, we may not know if the seller is going to be adversely affected by some of these changes. We don't know if this will inherently delay close of escrow. We won't know any of that until the end. So I personally am not a big fan that we allow this. At the end of the day, I'm like, well, no, they said type of financing. We are now changing the type of financing. Does that not change line 97 of the purchase contract? That is my personal stance, my personal soapbox, but section 2K allows this to be done. So just know the difference and don't get your panties in a twist when ultimately you see some of this come through, because it is allowed. Appraisal contingency. Buyer's obligation to complete the sale is contingent upon an appraisal of the premises acceptable to lender for at least the purchase price. If the premises fail to appraise for the for the purchase price in any appraisal required by lender, buyer has 5 days after notice of the appraised value to cancel this contract and receive a return of the earnest money, or the appraisal contingency shall be waived unless otherwise prohibited by federal law. Okay, those are your FHA and VA loans. They're going to have an amendatory clause that is going to supersede this appraisal contingency. Now, that doesn't mean that an FHA or VA buyer can get their earnest money back for any reason. It is specific to the appraisal, meaning that they cannot waive their appraisal contingency. It legally cannot be done. There's nothing they can put into a state contract that will supersede federal law. So that is just something to be aware of. Again, not in this market, but in a seller's market, we saw that left and right, and it just can't be done. Understanding that value in this way, failing to appraise, it does also include conditions. So those conditions mean that the home only is worth this much. It only appraises if these conditions are met. Painting this, affixing this, closing off, capping wires, whatever the case may be. The appraiser may call out some of those conditions. Where I'm often seeing issues is we are negotiating a reduction in sales price. We're trying to come to terms, and we are taking more than 5 days to do so. That 5 days is critical. If we need more time because the seller has submitted a reconsideration of value, then we need to draft an addendum to extend the appraisal contingency period. Otherwise, no matter what's going on in the background, if our buyer doesn't do something within those 5 days, they are moving forward and they are paying the difference. So please, please make sure you are aware that that needs to be handled within that 5-day period. If we can't get the seller to lower, the buyer can't pay the difference, there is an actual form for canceling for this reason, and it is the appraisal contingency addendum. Appraisal costs. Initial appraisal fee shall be paid by buyer, seller, other. I guess that could be an agent or a lender. At the time payment is required by lender and is non-refundable. Only if seller is paying the initial appraisal fee, the fee will or will not be applied against seller's concessions at COE if applicable. So if the buyer or somebody else is paying for the appraisal, you won't mark anything on these two boxes. They do not apply. So it's only if the seller is paying the upfront cost of the appraisal that this is indicating, hey, if the buyer asks for $5,000 in concessions and the appraisal is $500, is this $500 being paid in addition to that $5,000 concession, or will it be subtracted from that $5,000 concession? That's what those two boxes are meant to show. If buyer's lender requires an updated appraisal prior to COE, it will be performed at buyer's expense, and any appraiser or lender required inspection costs shall be paid for by the buyer, even if they have to come back out again and again because the seller did not get the items done that were conditions. So if you don't want that to be the case, that's something you would need to address in the additional terms. All right, we are hitting time very quickly. I knew that this was going to be the full part, especially with financing. Any questions about this section?
I do have a question on the appraisal. So basically leave it blank. Don't put buyer, seller, or anything on there. Is that what?
No, so no, the part to leave blank would be 112, only if line 111 is marked buyer or other.
Got it.
So line 111 needs something checked. Line 112 only needs something checked if line 11 is marked for seller. Okay. We are an entire section behind, and it is already 10:12. So here is what I am going to do. I'm going to move forward with section 3. It will probably take another 15 minutes. Feel free, drop off if you need to, knowing that this recording will still be sent to you so you can catch the rest of it later today when that comes out. But I want to make sure that we get through it. And if you're able to hang around for another 15 minutes, excellent. So let's go to poll 3. Who chooses the escrow company? Buyer, seller, or it depends? Buyer receives the CC&Rs 3 days after their inspection period has ended. Can buyer cancel and have their earnest money refunded if they disapprove of something in the CC&Rs? And in the case of an earnest money dispute, who decides how the earnest money will be dispersed? The buyer and seller, the escrow company, a judge, any of the above? Five seconds. Okay, who chooses the escrow company? The overwhelming number of you said buyer, which is not correct, and yet that's what consistently is being taught in CE classes, and it's driving me crazy. The it depends is actually the best answer, because at the end of the day, it depends on who negotiates it. So the way our contract is written, in Arizona, the seller pays for the Alta title insurance policy, which is kind of one of the caveats. But the bigger situation to this is there is a difference between your title and escrow company who is facilitating the sale and the title insurance provider. For those of you who have had a few deals, you may have noticed that you're closing at, let's say, Great American Title, but the actual title insurance policy is being underwritten by Fidelity or maybe by Stewart or by Chicago. That is what the buyer gets to choose, not who the escrow company is. So this is not an argument. This is totally negotiable in the contract. There is no right or wrong. At the end of the day, you just need to decide collectively how you're going to go about this. The Nika who's not the Nika, Veronica.
So I got a offer before, and under additional terms, it said the agent put per section 9 of RESPA, seller cannot require the buyer as a condition of the sale to use the seller's title unless the seller agrees to pay in full both the owner and lender's insurance policy and all title charges.
Oh yeah, I've got a great response for that, and it's roughly a page long. So if you bump into that, reach out to me and I'll give it to you because they're about to be educated.
Okay.
Yeah, that is not correct. So this is a misinterpretation, whereas it is true that the buyer can decide who their title insurance is provided through, and they are welcome to acquire that. Realistically, you could even have two totally separate title and escrow companies facilitating the same sale. Stupid, and it's going to be less cost effective, but it could legally and legitimately be done. But what the buyer gets to pick has nothing to do with who the actual title and escrow company is. That is, it's the title insurance. So ultimately, that's where we're just going to let them know. Now, if we don't want to necessarily agree to that unilaterally, but depending on how exactly that is written, we may still be compliant because they've worded it in just such a way that they don't even understand, hey, that doesn't mean they get to choose the title company. But that might be something that we counter. And if we want to be super snarky, we will counter it with a please see attached explanation for why your seller was wrong in putting this in the contract in the first place. Buyer receives the CC&Rs 3 days after their inspection period has ended. Can buyer cancel and have their earnest money refunded if they disapprove of something in the CC&Rs? Yes, they sure can. And God, this is so frustrating when it happens late in the game. So please make sure you're staying on your title companies and that they have the correct email address for the buyer. Some sort of acknowledgement that the buyer has received the CC&Rs would be fantastic. So you're not a day before closing and all of a sudden they finally get the CC&Rs and they decide that they are going to cancel. Again, super, super frustrating. But legally, contractually, they are able to do so. In the case of an earnest money dispute, who decides how the earnest money will be dispersed? For those of you who put the escrow company, I know why. Yes, the contract says, hey, they will do that in their sole and absolute discretion. But realistically speaking, the buyer and seller can decide. They can determine how they want. Maybe they're going to agree to 50-50. A judge, if it goes that far, like small claims court, an arbitration panel might ultimately be the deciders. So it's really any of the above. But you are correct, those who selected the escrow company as far as what the contract says, who has sole and absolute discretion. The problem we're bumping into is sometimes they don't make a decision and then it has to go elsewhere. So title and escrow. This contract shall be used as escrow instructions. The escrow company employed by the parties to carry out the terms of this contract shall be, and it's their information there. Title investing. Buyer will take title as determined before close of escrow. If buyer is married and intends to take title as his, her sole and separate property, a disclaimer deed, probably not may. I guess she could do a quitclaim deed or he could do a quitclaim deed, but may be required. Taking title may have significant legal, estate planning, and tax consequences. Buyer should obtain independent legal and tax advice. Under no circumstances are you to have this discussion with how they should take title. Under none. They need to seek professionals for that. Title commitment and title insurance. Escrow company is hereby instructed to obtain and deliver to buyer and seller directly, addressed pursuant to 8S and 9C or as otherwise provided. Okay, that's just buyer and seller contact info. A commitment for title insurance together with complete and legible copies of all documents that will remain as exceptions to buyer's title or buyer's policy of title insurance, the title commitment, including but not limited to conditions, covenants, and restrictions, deed restrictions, and easements. Buyer shall have 5 days after receipt of the title commitment and after receipt of notice of any subsequent exceptions to provide notice to seller of any items disapproved. Again, we've got a lot of these 5-day periods in here. So in essence, anytime a buyer receives something, they have 5 days to review it and disapprove of any items. Seller shall convey title by warranty deed, subject to existing taxes, assessments, covenants, conditions, restrictions, rights of way, easements, and all other matters of record. Buyer shall be provided at seller's expense an Alta homeowner's title insurance policy, or if not available, a standard owner's title insurance policy showing title vested in buyer. Buyer may acquire extended coverage at buyer's own additional expense. And if applicable, buyer shall pay the cost of obtaining the Alta lender title insurance policy. So if they have a loan, that they would need the lender title policy in place for that. So really, this is all knowing you've got the 5 days to review anything that's coming from title, but really it's telling title, hey, here's what we want you to do. You need to go about providing all of this information, arranging for these types of insurance policies. The standard owner's policy, we will see that with REO properties. And what that means is that they are not guaranteeing the chain of title to the end of time or the beginning of time. They're only doing it for as long as they've owned the property. So just, it's not necessarily a huge concern per se, but it is something to be aware of. If you see that, that's what it's referring to. Questions on this?
Leah,
Yes.
quick question on the title commitment. Can the buyers just say we disapprove, or do they have to actually show that there is something they're specifically disapproving of and not use it as a get out of jail free card?
They would have to designate what they're disapproving of. So similarly to the Binzer, and this would be curable if they have not. Again, I think that's kind of a waste, but they should designate exactly what it is that they're disapproving of.
Perfect. Thank you.
You're welcome. And part of that just kind of goes into acting in good faith too, right? Like we're not just using these things as a get out of jail free card. We legitimately have to explain why. All right, additional instructions. Escrow company shall promptly furnish notice of pending sale that contains the name and address of buyer to any homeowners association in which the premises are located. If escrow company is also acting as the title agency, which most of them are, but is not the title insurer issuing the title insurance policy, escrow company shall deliver to buyer and seller upon deposit of funds, earnest money, a closing protection letter, earnest money and their $25 for the closing protection letter or the CPL, from the title insurer indemnifying buyer and seller for any losses due to fraudulent acts or breach of escrow instructions by escrow company. All documents necessary to close this transaction shall be executed promptly by seller and buyer in the standard form used by escrow company. Escrow company shall modify such documents to the extent necessary to be consistent with this contract. Escrow company fees, unless otherwise stated herein, shall be allocated equally between seller and buyer. Escrow company shall send to all parties and brokers copies of all notices and communications directed to seller, buyer, and brokers. And escrow company shall provide brokers access to escrowed materials and information regarding the escrow. If an affidavit of disclosure is provided, escrow company shall record the affidavit at COE. That's really a bunch of stuff that you probably don't need to know much about. It's just giving instructions to the title company for what we want them to do. Again, a lawyer wrote it, you can tell. Tax prorations. Real property taxes payable by seller shall be prorated at COE based on the latest tax information available. And we do pay taxes in arrears. So if clients are not familiar with how that works, the title company will be happy to explain it to them. That way they know, hey, this is why this is showing up as a credit versus a deduction. And if anything might have to be paid outside of escrow, especially in a cash deal, just kind of based on the timing. Release of earnest money. In the event of a dispute between buyer and seller regarding any earnest money deposited with escrow company, buyer and seller authorize escrow company to release the earnest money pursuant to the terms and conditions of this contract in its sole and absolute discretion. Buyer and seller agree to hold harmless and indemnify escrow company against any claim, action, or lawsuit of any kind, and from any loss, judgment, or expense, including costs and attorney's fees arising from or relating in any way to the release of the earnest money. So as many of you stated, yes, the contract does give them that right, although ironically, for those of you who took my class on the MLS Choice or the non-member MLS Access contract, for those who are no longer NAR members, they actually removed this. So it specifies that you have to go straight to mediation or arbitration for earnest money disputes. The title company does not handle those. I will say again, in my experience, I'm seeing more and more often or if it is not super black and white, that the title company will not make a ruling on the disposition of earnest funds. And they will tell you, you need to go to small claims court, you need to work it out, or you need to go to mediation and arbitration to resolve this. So they're just kind of the first stopping place, if you will. Prorations of assessment and fees. All assessments and fees that are not a lien as of COE, including homeowners association fees, rents, irrigation fees, and if assumed, insurance premiums, interest on assessments, interest on encumbrances, and service contracts shall be prorated as of COE or other. You really should not ever have anything else on that line. It's prorated as of COE. If there were any other agreements, those would actually be completely separate agreements outside of this contract. And assessment liens. The amount of any assessment lien or bond, including those charged by a special taxing district, such as a community facilities district, shall be prorated as of COE. For my new kids on the block, you are very lucky. CFDs were highly prevalent and still are in some cases. And they were large amounts. I mean, in some cases, you're talking $7,000 or $8,000. And that's when the average sales price was $220,000, especially in master planned communities like Estrella Mountain Ranch. And these had to be negotiated separately, and they got missed all the time. So it was a major point of contention at closing. Thankfully, the majority of these districts have actually merged into taxes. So you wouldn't even know. You're just in a special taxing district. It's just in your regular property taxes. You don't even know that it exists. But there could still be a couple out there about which I'm not aware. Questions on this? I know this is the section that everybody's just like, okay, let title do their job and let's hope for the best. With the exception of the earnest money, that's usually the thing that we want to cover most.
Leah, it's Anna. I have a quick question on the CPL letter.
Yes.
I had a situation where the transaction didn't happen through me, but I had a client that sold through Open Door.
Mm-hmm.
And one of the secondary liens on the mortgage that happened during COVID, they had like where they would defer the loan.
Mm-hmm.
So that payment got missed. It was like 14,000. So does the CPL cover that? Because it was essentially like the title company that didn't pay it, or does it like go through title insurance?
It would still go through title insurance, but that's what that CPL is for. So in essence, all the CPL is doing is saying, hey, we, the title company, are not actually the ones providing title insurance. So that's just creating that little extra connection between the title company and the title insurance provider in that case. But the actual claim would still go through whoever's holding the title insurance policy. So if it was something that was missed, and honestly, it may not even be, well, no, I'll leave that off. So let's say that you closed through Rock Title, but Fidelity was the title insurance provider. You could start with Rock Title to get some information, but really the actual claim would be going through Fidelity.
Okay, thanks.
You're welcome. Anybody else?
I have a question on the front page, and I think I know the answer, but I want to hear what you have to say. When you say that we should not conduct pre-closing walkthroughs on behalf of our buyers, is that just for liability reasons of if we miss something, they can't come back on us?
Correct. And the majority of E&O providers have a provision, an exception provision that says, hey, in essence, if you, the agent, did this, we won't cover your E&O claim either. And I mean, that's a huge problem. Because if you don't have E&O coverage, that means that you are on your own financially for litigation.
Okay.
Kind of a follow-up to that, Anne, and I have major concerns with this, especially during the wake of COVID, right? We were doing virtual showings, which in my opinion also kind of serves similarly to a virtual walkthrough of sorts, but they did distinguish, hey, it's one thing to do a virtual showing. The expectation is still that prospective buyer is going to set foot in the property during their due diligence. It's another thing to do it at the end during a final walkthrough, because even a virtual one, what if you didn't pan your screen up just high enough? What if the volume was turned down enough that they couldn't hear whatever noises were going on in the neighboring property? So that's why we're like, just don't do it. Just don't do them at all.
Hey, Leah.
Else? Oh, yes.
Yep, really quick. If they do assign like a friend or a relative to do the walkthrough for them, do you need something in writing saying they assign a certain person to do that for them?
No, so what, not necessarily, yes, in writing, but not what you're thinking. So I don't need a separate document. The proxy would actually sign the final walkthrough form on their behalf, and they would do it their name, comma, proxy.
Okay, perfect. Thank you.
You're welcome.
Okay, I have a question. I feel like it's gonna be a silly one, but in section 2K where we were talking about seller concessions, it specifically states that it can be used for broker compensation. Does that mean that we technically don't need the SCA anymore if they put a certain percentage in here?
Great question. And no, so I'll tell you why. I think that this is separation of church and state personally. I think that it is best negotiated where concessions are one thing and buyer broker compensation is another. So while this would allow that to occur, and this could even be excess buyer broker compensation. So let's say that your BBA is for, I hate this stupid nonsense, but let's say for 5 bananas, okay? You submit an SCA and they counter back that they're only going to pay 3 bananas, but they also get concessions. The buyer could apply their extra concessions or apply some of their concessions to compensate you for those additional bananas. They could use it all, they could use some. That will just allow them to do so. But strictly speaking, best practice is utilize that SCA for buyer broker compensation.
Okay, thank you.
You're welcome. All right, my friends, I appreciate you hanging for an extra 15 minutes with me. Like I said, I'll get all of this out to you later. I hope to see you next Wednesday for the next segment of this. And if you do have any other questions, just reach out and let me know. Bye, everybody.
Thank you.
You're welcome.
Thanks, Leah.
You bet. Have a good day.
Thank you.
You too.
Thanks, Leah. Thank you.